We started Modern Ideas for Business with the goal of creating an interactive forum where business leaders can learn from experts in a variety of fields, ask questions, and share their thoughts and opinions on the topic of the day. So if you have questions or comments during the webinar, please feel free to enter them in chat or the Zoom Q&A, and our speaker will address them at the end of her talk. I'm happy to introduce our speaker, Lisa Ann Hilario, an employment attorney and partner at Spaulding McCullough Tansil LLP. Lisa Ann counsels employers on all aspects of the employment relationship and related legal compliance, including wage and hour issues, leaves of absence, disability accommodation, employee discipline and termination, reductions in force, and investigations of employee misconduct. She also develops personnel policies and employee handbooks and drafts employment-related contracts. In addition to her employment counseling practice, Lisa Ann defends employers against wage and hour litigation, wrongful termination actions, sexual harassment and employment discrimination cases, and other employment-related claims. So Lisa Ann truly is an expert who can help us understand the new employment laws taking effect in 2026, the potential impact on our businesses, and how to ensure our businesses are in compliance. So with that, Lisa Ann, I'm happy to turn it over to you.
Thank you, Dave, and thank you for having me come speak with your group today. Appreciate the opportunity and look forward to giving you some great up-to-date information about employment laws in 2026. One of the things I always want to bring up in the beginning is that the information I'm going to give you is a smattering of all the new changes in law. There are likely areas where there may be some questions about underlying issues. Feel free to ask those. I can give general legal information, but I won't be giving legal advice specific to any one employer's situation. But I am more than willing to talk with people offline about that and talk with them if they're interested in becoming a client. The information I'm going to provide, it reflects the new employment laws taking effect in January 2026, and the effective date is different. I will let you know. Law changes constantly, so this information is true as of today and hopefully the foreseeable future, but there are occasions where there are changes in the law. So if you happen to be listening to a recorded version of this seminar, say in July of 2026, just know that this reflects what's current in January of 2026, and you need to make sure it's still effective then. We have a lot of information to provide today. This seminar is usually 2 hours. I give it to clients. I'll be trying to get it into 50 minutes, which means I'm going to be really speeding by some of the slides, but I did provide a handout of all the slides to you that you have this information and can reference it to the extent I need to go through a slide more quickly than perhaps I would in a longer session. We'll find, in addition to providing the slides, I've also provided an action item list. And you will see on the slides at the end of each new law update, I give you action items. That means things that your company needs to do to check to see if you're in compliance or to become compliant with the new law. And those action items in those slides are cut and pasted into a separate action item list that's meant to act as a checklist for you. So all of the action items from the slides have been put out in the action item list so that you can use that as a checklist for your company, get into compliance or to audit for compliance. So with that being said, I'm going to jump in and start. Always start the seminar with a wage and hour update. These are updates to the laws that impact how pay your employees. I do want to say up front that unless I say otherwise, all of these laws apply to all employers in all sizes. If there is any limitation, for example, if a law only applies to a larger employer, I will let you know that. Otherwise, all of these slides apply to all of you in all industries. So in the wage hour update, I always start with the fact that the labor law poster that you hang in a central area in your office need to be updated.
I'm sorry, Lisa. I don't see your slides.
Thank you. I shared myself and forgot to share.
It's
my
easy
slides.
to do.
Thank you so much. All right. How about that?
Perfect.
Okay. So in the common area in your office should be a labor law poster. It will look something like the picture on a slide. Many people, well, we don't have an office anymore, or we have employees who work an office, but we have employees who work remotely. Unfortunately, that does not change your obligations to post the employment laws. So not only do you need to update the poster that's in your office, typically the supply room or the employee break room, but if you have remote employees or 100% remote employees, you do need to get the posters to them because it is a requirement. The other thing I want to mention is the posters. A lot of people just get them and they pull them out and tack them on the wall without realizing that there are areas of the poster that you have to fill in with information unique to your business. So get the poster, look for the blanks in it, fill them in to fit your business, and you will be compliant on the labor law posting requirements for state, city, state and federal law. Understand that in some cities, they have their own postings, and you will have to look at the city where you have your, or where your employees work. Yes, where your employees work, if they're remote, does mean you are subject to the laws of the city or the state where your employees sit in the chair and do the work. So if you have remote employees, if you have your office, say in Oakland, but you have remote employees working in San Francisco, you have to post the San Francisco postings as well as the Oakland postings. Same if they're out of state. All right, next, every January in California, we see an increase in the California minimum wage. 2026, that amount is $16.90 an hour for all employees. Most of my clients will tell me, well, that's not a big deal. We pay more than minimum wage. However, what I need to let you know is that the increase in the minimum wage does have certain ripple effects to other areas. For example, your employees that you pay on an exempt salary basis, and exempt employees are those employees who are paid a fixed salary and not paid by the hour. Those exempt employees, in order to be exempt, must earn at least 2 times the California minimum wage. So therefore, when the minimum wage goes up, that minimum exempt salary goes up. For 2026, that's $70,304 a year. Please note that that amount cannot be prorated. So even if you have an exempt employee who works only 1 day a week, they have to make $70,304,000 on a fixed salary basis. Fixed salary basis means that amount divided by 52 weeks is their weekly salary. There are some exceptions for exempt healthcare workers where there is a potentially different minimum. You will see that in a minute. If you work in the construction industry and you require that your employees provide their own hand tools, screwdrivers, saws, hammers, they have to be paid at least 2 times minimum wage, which for 2026 is $33.80 per hour. If you are not paying them that much, then cannot require them to provide their own hand tools. So if you have laborers or people that earn less than $33.80 an hour in the construction industry, you must be providing all of the tools for the work. You have employees paid at 2 rates of pay. For example, many employers will pay a higher wage for the regular work, but use minimum wage to pay for travel or training. Understand that you need to increase that minimum wage work rate as well. There are some people that have exempt employees who work on commissions, or they have employees under collective bargaining agreements. Understand that increases in minimum wage do affect those individuals as well. The action items for the wage increase are listed here. They are also listed on the checklist that was provided. Moving on now from California law, so the California minimum wage applies to the entire state. There are also other minimum wage rules that may apply. In this case, there are certain industries that have a separate higher minimum wage that is different than the California minimum wage. So if you have healthcare workers actually have scheduled increases in the minimum wage since October 16th of 2024 that are increasing over the subsequent years until they reach $25 an hour. The specific minimum wage amounts and the frequency of the increases vary according to the type of covered healthcare facility and the published wage schedules. So if you are in healthcare industry, you should check out this law to figure out if it applies to you and to whom it applies. It will apply not only to healthcare workers who earn on an hourly basis, but also to healthcare workers who earn money on an exempt salary basis. They have to have a higher minimums than the California requirement. Because it was an October 2024 law, when I did my update in 2025, I provided all the information. Because this is a reminder slide, I have not provided all the information again, but I have told you where you can find it. You can find it on this website here that has the FAQs for the healthcare worker minimum wage law. The information about the hourly employee wage schedules are found in FAQ 12, and the exempt employee salary rules are found in FAQ 16. If you are wondering whether your employer or your business is considered a covered healthcare facility or whether the employees are covered employees, that is defined in Labor Code Section 1182.14, and you can Google that and look at the very long list to see if it fits. Here are the action items for that: reviewing the rates and raising them if necessary, as well for hourly employees, as well as exempt employee salaries. If you're in the, I didn't put a slide on this because there will change, but a reminder, if you're in fast food, there is a fast food minimum wage. It may or may not apply to you. It really depends on how many locations you have. But you can look that up on the internet as well or contact me. In addition to industry minimum wages, we have multiple cities throughout California that have their own individual minimum wage. I've provided on the next several slides minimum wages for cities in Northern California. There are many in Southern California, which I have not provided. You can go to the city where you have employees working and look at what their minimum wage is if they have one. Most of them take effect on January 1, 2026, but there are some that take effect in July of each year. Those are indicated here by an asterisk to remind you to look and find out the new wage in July 2026. Most of them apply to all employers in those cities. However, there are a select few, Hayward being one of them. The minimum wage that applies depends on how many employees you have. So the next several slides will go over those other cities. You can look at those on your own. But I'd like to identify a few things because I have a lot of clients who say, well, I don't have to comply with that law because I don't have my business isn't located in that city. However, what I want to point out is that number one, you do to consider where the employee is working. Most of these ordinances apply when an employee works for 2 or more hours in any week within the city. So if you have your business principally located in San Francisco, but you have employees who work in LA, maybe remotely, maybe even just hybrid, you have to comply with the law where the employee works. This has led in the post-COVID era where many, many employees are working remotely. It has led many of my clients to have to follow the laws of many, many different. This also applies if you have employees in other states. So if you take advantage of the fact that you can hire employees that work what was traditionally considered a commute distance, understand that there is a large business cost associated with that. It may require you to pay them differently. It may require you to comply with different leave laws and even have different benefits. So very, very important, consult with an employment attorney if you have employees working in multiple cities or states. Incidentally, time spent through a city is not subject to the ordinance, but if you have an employment-related stop in the city, it does. So if you work in Santa Rosa and you have delivery drivers that deliver in San Francisco for 2 or more hours a week, your employee needs to be earning paid sick leave and being paid minimum wage under San Francisco law for that time spent in San Francisco. So it's a very, very complicated laws that now apply when you have employees that work even part-time in other cities. All of the ordinances also have notice and posting requirements. So know that if you have employees who work in others, you need to know what postings and notices are required in those cities to give them to your employees. Here's the action item list of the to do to stay in compliance with these laws. Moving beyond minimum wage now, there are some new laws in California regarding tips and gratuities. I've given you here what the existing law is. The existing law is that employers cannot collect, take, or receive tips left for an employee. So you can gather them, but you must then issue them to the employee. Employers cannot take any part or any of tips that employees leave for that customers leave for employees. You cannot deduct wages due to employees' tips. and cannot participate in tip pools. In 2026, we see an enforcement power. The new law gives the labor commissioner the power to investigate, issue citations, and file civil actions for gratuities that are unlawfully withheld. So if you have employees who earn tips, ensure that you have written tip policies and practices, that they comply with the law, that managers, supervisors, and owners are not participating in the tips, even if they are also providing customer service, and ensure that your terms of tip pooling arrangements are all right. In existing law, for a couple of years now, employers of 100 or more employees have been required to gather and submit certain pay data to the California Civil Rights Department by the second Wednesday of May of each year. The existing law outlines specific pieces of demographic information that has to be provided to that department. Effective January 2026, there are new categories of demographic data that have to be collected. They've provided categories that they're going to that they are to track. They've increased it 10 to 23 specific categories. So for 2026, when you make your when you data pay in May of 2026, you do not have to report this new data because you are reporting for the 2025 calendar year. However, when you report in May 2027, you will need to report these new categories starting for 2026. So you need to start collecting the new data starting January 1, 2026, so that you have it to report in May of 2027. All right, some updates on the law on job posting requirements and pay scales. Prior to this year, employers could not ask about their salary history or what they were their current or last job. It requires employers of 15 or more employees to include pay scales in job postings, and it defines a pay scale as the salary or hourly wage that the employer reasonably expects to pay for the position. A revision to this law effective January 1, 2026 defines pay scale a little bit more as including a good faith estimate of the salary or the hourly range that you reasonably expect to pay for the position upon hire. Action items for this list: making sure that you are reviewing and setting pay scales for each job position, and that you are posting those when you post for job openings. If you have 15 or more employees, you need to include the salary scale. All right, Equal Pay Act, that law, January 2026. The law prohibits you from paying different employees different compensation based on sex, race, or ethnicity, and requires that you be able to prove that any wage differentials between employees are based on bona fide business factors and not sex, race, or ethnicity. The law before this year was that employees had 2 years after the violation occurred to file a lawsuit, or 3 years if the violation was willful. The change in January 2026 extends the deadline to file a lawsuit from 2 years to 3 years from the last violation. So that means that if I have a violation today, I allege that has going on for the last 3 years. I have 3 years from now to file the suit, and it can cover the whole 6 years of violations because it's 3 years from the last violation, but the employee can go back up to 6 years to get back wages. Action items here include performing an equal pay audit of your positions and making sure that you can demonstrate that wage differentials are based on permissible factors. All right, every year we have an increase in the IRS mileage rate. For 2026, it is 72.5 cents per mile for business use. That's up 2.5 cents a mile from 2025. This is a safe harbor rate employers should use to reimburse their employees for using their personal vehicle for business-related driving. So make sure that or payroll department, whatever department you have charged with reimbursing employees for business mileage, that they know about this increase and that they are reimbursing properly starting January 1. All right, in July of 2025, we saw the One Big Beautiful Bill Act passed. There are 2 parts of that law that affect employment. It introduced 2 new income tax for employees for tax years 2025 through 2028. I want to emphasize that this is a tax deduction for employees. This is not a deduction for employers. It allows employees to take deductions for qualified tips. Qualified tips are defined as cash tips Now that term is used broadly. It does also include tips left by credit card, but does not include mandatory service. So it has to be a qualified tip. To be a qualified tip, the employee has to be working in an occupation that is customarily and regularly receiving tips. The IRS has defined what those occupations are. Do not assume that because your employees get tips that they automatically get this deduction. Your employees have to be performing work in one of the occupations listed on this tipped occupation posting. So if you do have them working in those locations, they are allowed to deduct from their taxes up to the limits listed here for qualified tips. And the second part of the act is they can deduct qualified overtime compensation. Now, qualified overtime compensation has two parts. One is it's only a deduction on the portion of the overtime. That's the extra half on the time and a half. So if you earn $20 an hour and your overtime is $30 an hour, you could deduct the $10 premium, but not the $20. Qualifier here is that federal overtime can be deducted. So it's only overtime paid for work beyond 40 in a work week. There are 6 states in the country that also provide daily overtime, meaning overtime for hours worked beyond 8 in a day or 40 in a week, and overtime worked on the 7th consecutive day in a work week. That overtime is not deductible. There's going to be a lot of confusion by employees not understanding that state and federal overtime are different. There's going to be some very difficult mechanisms for tracking this, but only the overtime for hours worked beyond 40 in a work week is deductible. So employees cannot deduct overtime due to special agreements. So if you have a rule that we pay everybody who works on Saturday at time and a half, that is a special overtime rule that the employer is agreeing to do either voluntarily or pursuant to a collective bargaining agreement. That overtime is not deductible. That is not federal overtime. Federal overtime is only the overtime beyond 40 hours in a week. And you cannot deduct overtime earned under state law. So if this is an employee deduction, how does it affect employers? Well, the new overtime tax deduction is not taken through payroll. The employee takes the deduction on their individual tax return. However, the employer has an obligation to report the deductible overtime on the W-2. So this is where we're going to see requirements for employers. However, as is true, the federal and state governments often have laws that have requirements that the business world needs time to adjust to. And one of those implementations was passing a law in July 2025 that allows for tax deductions in 2025, didn't take into account that no employers were tracking that information in 2025. None of the payroll companies have a mechanism for reporting and tracking that time separately. And even the IRS form W-2 hasn't been revised to reflect the new law. So for tax year 2025 only, employers are not going to see a change in the form W-2 or the form 1099. Employers do not have to comply with the reporting requirement for tax year 2025. So your employees may ask you for it. You are not required to provide it. There's a relief from transition and penalties for tax year 2025. So you can tell employees that they can take the deduction, but you don't have to tell them how much. If you want to tell them how much, you could make a good faith effort at determining what that would be, but you are not required to report it for tax year 2025. However, starting tax year 2026, which started January 1, 2026, you are required to report qualified deductible tips and qualified deductible overtime on employee W-2s. So while you won't be preparing 2026 W-2s until January of 2027, you must start tracking that information now so that you will have the ability to track it and report it in 2027. Now, unfortunately, the payroll systems haven't had enough time to catch up. So contact your payroll provider to find out how they're going to help you figure this out so that you can do the proper at the end of the year. So as I mentioned, for 2025, you can voluntarily provide a separate accounting of qualified tips and qualified overtime if you want. If you don't want to, you can refer employees to this IRS notice, which the IRS is telling employees how they can go about figuring this out. But during this year, you should definitely determine today, do we have employees that earn qualified tips? If we do, we better start figuring out how we're going to track it. And do we have employees that get qualified overtime? If so, how are we going to track it? All right, that is the end of the wage and hour portion of my seminar. The next one relates to updates and laws that affect employee benefits. Every year in California, we seem to find a new reason that people can use their paid sick leave. Employers in California are required to provide paid sick leave to all employees, even the very most part-time and temporary employees. If you don't provide paid sick leave, but instead you have a PTO policy, that is fine as long as it meets all of the requirements of the paid sick leave law. So that means even if you don't offer sick leave and you offer PTO instead, you have to take a very careful look at any changes in the paid sick leave law, because your PTO policy has to be made at least to comply with the sick leave law. If not, then it will not qualify and you'll be in violation. So before January 1, 2026, we had multiple reasons beyond illness for which people could use paid sick leave. I've listed them here. Hopefully you already know about them, but if you don't, please look at them. You can see here there are worth of reasons people can use sick leave. Most of them have nothing to do with being sick. However, starting January 2026, there is one new reason people can use sick leave. It's time that they take off to attend judicial proceedings if the employee or their family member is a victim of certain crimes listed in Government Code Section 12945.8. There are many, many crimes listed there. I didn't list them. What I always tell employers is don't say no without checking the law. So my clients will either call me or they will then pull up whatever their resource of law is and say, hey, my employee wants time off. Do I give it? And then we'll look up the law. But know that there are all kinds of California where employees can get protected sick leave or protected leave of any type. So I always tell people, if you want to say no, check, because you want to make sure there isn't a law out there. So for this change, you want to make sure that you update your employee handbooks and policies, your sick leave provision, your PTO provision. You want to make sure that supervisors, HR, and payroll personnel are trained so that they are not telling employees they can't use sick leave when in fact the law says you can. All right, there's a change to California paid family leave insurance. This is a benefit by the state that employees contribute to every paycheck. It's similar to SDI. SDI, state disability insurance, is for employees to have income replacement from the state when they are off work due to their own illness. California paid family leave insurance is a similar that allows employees to receive insurance benefits from the state for up to 8 weeks when they are taking time off to care for a qualifying person with a serious health condition, as listed here. And also for baby bonding leave. Starting July 1, 2028, and I realize that's far into the future, isn't it nice how when California adopts a law, they give you a 1.5 year notice, but the feds gave us no notice. In any event, effective July 1, 2028, employees can now use paid family leave insurance to care for a designated person with a serious health condition. This allows an employee each year to identify someone for whom they want to receive benefits, even if they are not in a traditional family relationship. The way is also under the sick leave law and under the California Family Rights Act. So if for those of you, hopefully this concept of designated person is new to any of you online, but if it is, understand that there's in July 2028 on paid family leave insurance. If you're not familiar with the designated person laws under sick leave and family medical leave, you should look into them because it has a similar provision where employees can designate people that they want to take leave to take care of. Action items here: updating your handbooks by July 2028. Because this is a July 2028 law, I will address it in my update in January 2027 to remind people. All right, moving on from employee benefits, we have an equal employment update. The first one relates to bias mitigation training, and I'm going to do very quickly because most people don't do it, but many employers, especially those that are part of industry groups have anti-bias training and compliance things that they do. And the worry that when we sit around and we talk how we might be biased in way of and recognizing ways in which unintentionally biased against members of different races, religions, etc. The fear was that sharing that could then be used as evidence against that employee if there were later a discrimination claim were later filed. This new law says that when you share that type of information in connection with training about eliminating bias, that is not evidence of bias and doesn't constitute unlawful discrimination. If you engage in these types of training exercises, know that you have some protection now that you did not have before. I'm going to speed past real quickly. Sexual assault and harassment complaints by employees. We have a statute of limitations. You can now go further into the future and into the past. So continue to be on the alert and take sexual assault and sexual harassment complaints very seriously. New law applying to all employers on or before February 1st, 2026, and annually. You have to provide current employees and new employees with what's called a Know Your Rights notice. This notice has to be given to new employees and every year. So you need to create a calendar to make sure that you issue this notice every single year. It can be done by hand, email, or text, as long as that's how you normally distribute notices. The language that has to be provided is listed here. But going down several slides, I will tell you that the commissioner has already established the notice. You see it on the link for required posters. What you want to do is download it and issue it to all of your employees. Keep a record of having issued it, and then calendar to issue it every January. It's just a simple emailing it out, texting it out. If you're going to post it on I would only say that that's not going to constitute notice unless you have a mechanism for letting employees know that something new has been posted. So if you choose to post it on your internet or on your intranet, I suggest that if you don't have goes to employees saying, hey, we've updated our intranet, that you send an email to all of your employees saying, we've posted the Know Your Rights notice on the intranet, see the notice and read it. To employment contracts. You may or may not be familiar with the concept of a pay or contract. Pay or stay contracts are generally contracts where the employer gives something of benefit to the employee, but requires them to pay it back if they don't stay with the company for a certain amount of time. This might be a signing bonus. This might be a relocation expense reimbursement. It might be an agreement to pay off a student loan. It might be an agreement to send someone to training. If you do any of those things and you tell the employee that if you don't stay with us for X amount of time, you must pay us back for those costs, then this is what the law applies to. There are very strong restrictions on that type of agreement now, and makes agreements void unless they follow specific requirements. I've listed here types of contracts, and you might find them in agreements, you might find them in offer letters, you might find them in just reimbursement agreements, but you want to look for those and then make sure that they are revised to comply with the new law. Here are the requirements. The repayment obligation has to be in a separate agreement from the main employment agreement or the offer letter. So it cannot be a clause in the agreement. The employee has to be advised that they have a right to consult with an attorney and that they have at least 5 business days to do so before they have to sign. Repayment must be prorated. So if I say that you have to stay with me for 2 years and you only stay for 1 year, I can't make you pay me 2 years back of expenses. I have to prorate it to 1 year. You have to employ the option to defer the payment until the retention period. So if the retention period is 2 years and I leave after, you have to give me the 2 years to the end of the second year to pay back that 1 year overpayment. And then the repayment can only be triggered if I voluntarily leave early or if I'm terminated for misconduct. And misconduct is not the same as cause. Misconduct is defined in the Unemployment Insurance Code and is a much higher standard. The new law also provides employees with the private right of action to sue their employer if they have a void pay or stay contract, and to file PAGA, Private Attorney General Act, actions on behalf of all employees. There are penalties. Industries that are targeted, this is very common in the industry, the retail, nursing, and healthcare. Typically, any industries where you are out, where it takes a lot of money and time to train someone, is generally where we see pay or stay contracts. So if you have these, I think you might review your contracts and offer letters to make sure they don't contain any unlawful agreements. And if they do, make sure that you revise, contact me, SMT, Spaulding McCullough Tansil, and I can help you revise. Because to be compliant. This new law does not apply to documents into before January 1, 2026. It only applies to new contracts and offer letters. So look at those and make sure you get compliant. Personnel files. We have a change in or an expansion in the types of information that you must provide if an employee requests to see their personnel file. It now includes education and training records. These are for people who maintain them. So it doesn't require you to create training records if you don't do training. But if you do training, you do have to keep certain information in the employee personnel file and produce it if they ask for it. So review those, make sure that your HR people are familiar with that new law. Independent contractors. So if you're in the construction trucking industry, there's a new amnesty program if you've been properly classifying workers as independent contractors when really they should be employees under state law. If you're in the construction industry, please check that out. I've also included a refresher on independent contractors. This is not new law. This has been the law since 2017, but it's still finding a lot of clients that are not in compliance. If you have any people that are performing duties for your contractor basis, in other words, paid 1099, not hired as an employee, not paid as an employee, you should consult legal counsel to make sure you've done that properly, because I find that 90% of the time employers are paying workers as 1099 independent contractors when under the law they are really employees and should be paid on a W-2 basis. So these next slides are a refresher on that law, and I'm not going to go over them, but they are here so that you can see if that might be an issue for your business, and if so, to me, and I can help you. COVID update, we do still some laws that relate to COVID. This one relates to industries in the hospitality and business services. Right after COVID, there's a new law that said that anyone that was laid off because of COVID, those employees in the hospitality and services industries who were laid off had a right to recall. And that required employers to recall the laid off employees before they hired brand new employees. That law has been twice since COVID. So here is the general requirements of the law. The new piece of law that has been extended from 12/31/25 to 1/1/27. So if you are in these industries, you are not familiar with your recall requirements, or you want to, or you are, and now know that it's extended another year. Contain more information about that if you are in those. All right, industry changes. We do have some changes, some new laws affecting the ag community. That's typically a very small component of the people who attend these seminars. I've listed them so that you know that there are changes, but I'm not going to go into them. There are some other industries. There's some meal period requirements for employees of water corporations. There are rest exemptions for safety sensitive positions at petroleum facilities. If you are in either of those industries, you should look at those new laws. If you are in a contracting business, meaning construction contracts, the existing law is that if you have a contract entered on or after January 1, 2022, the direct contractor, in this case, typically the general contractor, is responsible for any debts owed or wage claimants by third parties incurred by subcontractors. So it makes you liable if your subcontractors are not paying their employees properly. This is a huge liability exposure for contractors. So that's existing law. So that's a reminder. If you're not familiar with this, you want to consult with counsel and talk about ways that you can ensure that your subcontractors are complying with wage and hour law, because you don't want to be held liable for their errors. And trust me, there are a lot of wage and hour errors in the construction industry. Intentional or not, they're there. And if you're a general contractor or you're subbing out a job, you do not want to be responsible for someone else's failures. So this slide tells you what the new change is. The change on January 1, 2026 requires direct contractors to assume and be liable for any indebtedness for the performance of labor. So it was just wages before, now it's any indebtedness. It also extends damages and penalties if the contractor knew of the failure to pay. So here are some, if you're in the contracting business, AI is on the forefront. Every year, we're going to see more and more about artificial intelligence. This is a new state law starting January 1, 2026. The Transparency in AI Act requires large AI frontier developers to have certain publications on their website and to disclose certain reports. It also creates whistleblower protections for employees that report AI safety violations. This is probably not anybody on this call, but if you are what's called a frontier developer, then you should know that new law applies to you, and you need to publish the required information on your website, as well as create a complaint process for your employees and develop and post notices annually. I always end these seminars with a slide that reviews not new law, but where we continue to see issues coming through, new law or not. In my practice, I'm starting to see a lot of issues relating to AI, relating to job descriptions, job postings, sorting through those, whether there's a discriminatory impact in AI assisting in that process. The worst would be people use AI in lieu of seeking legal advice. There's a lot of misinformation on the websites. I have clients sending me AI all the time, and it's just plain wrong or it's too vague. It's just wrong in a lot of circumstances. So AI can be used in helpful ways to get ideas, but it should not be used for making legal decisions about compliance. I'm continuing to see employers faced with more class actions and private attorney general act actions, labor commissioner complaints, demand letters, and lawsuits, particularly about wage and hour violations, rest and meal break violations, overtime violations. Those are coming through. We have employee attorneys throughout the state posting Facebook ads seeking clients. If you have not had a wage and hour audit done in the last year or two, you should. There's a lot you can do to clean up and avoid liability. If you don't have employment practices liability insurance, EPLI insurance, I encourage you to look into it, see if you have it, see if it covers defense costs for wage and hour cases. Or if you're not sure, ask your broker. If you don't have this insurance, I encourage you to look into getting it. It's kind of like earthquake insurance for homeowners. It's very expensive, but we are seeing so many wage and hour cases and lawsuits that can result in hundreds of thousands of dollars of defense costs and liability that it's really becoming part of the necessary insurance package. We're starting with the economy changing. We're starting to see more layoffs. If you are still going to do a layoff, you need to plan in advance. If you are subject to WARN and CalWARN requirements, you need to have more than 60 days notice to your employees. If you're not subject to that, or whether you are subject to WARN or not, you need to develop strategic processes to ensure that the people that you are laying off, you have equitable and defensible layoff procedures so that you don't face a discrimination, that you laid off the people who took a leave of absence, or you chose people for layoff because of their race or ethnicity. So oftentimes clients will consult with me. We will look at the layoff. We will kind of test it and see if there are any protected class claims that could. This is making layoffs a strategic process that you need to follow. So you need to plan. It's not something you can do on 2 days' notice. We're also continuing to see a lot of workers make complaints about hostile and toxic work environments and the need for workplace investigations. So those are things we're seeing in 2025 that we think are going to increase in 2026. And you can reach out to me at Spaulding McCullough and Tansil if you'd like to consult on these issues or any issues relating to employment law compliance in your business. I also have a full service law firm. So if you need to any attorney in estate planning, business, intellectual property litigation, I have 16 attorneys in my office who do that work. I can certainly direct you to the right person if it's not me. So thank you for listening to my seminar. I apologize for it being so quick, but I did want to leave time for questions, and I'm willing to stay beyond 11 if that's needed. So thank you.
Lisa Ann, thank you so much. Though I'm a sole proprietor, I always find webinars like this so that I can be a advisor to my clients. In fact, as you were talking, I was thinking I have several clients in commercial and residential construction, as well as in commercial painting company and other trades that I think can really benefit from watching this after the fact. So thank you for that.
Oh, you're welcome. And if I say one more thing, I have found that one of the parts of a seminar that is relevant, even you who does not have employees, that independent contractor test, because I find a lot of people call me and say, I don't have any employees. I use only independent contractors. And those people really should be employees under the law. So even people who don't have employees need to pay good attention to that law. Make sure that your independent contractors are really independent contractors under the law.
Yeah, great advice. I did run into that early in my career, so good to go back and check. So, Ed, do you want people to talk? And if they have questions, I don't see any in the was one in the chat that I think you can. Do you want to go ahead and enable people to speak up or yourself?
I'm working on it now, but I do kind of prefer it when you read them.
Okay.
But I am freeing them up. Sometimes I end up with blank screens.
I'm looking at the chats and I'm not finding any questions other than about the handout. Am I missing a substantive question? You mentioned there was one.
I think the question was, do changes to pay or stay contracts apply only to new contracts? And just after the question came in, I think you answered it.
New contracts entered after January 1 offer letters.
Exactly. Anyone else with any questions that they want to ask? I think for me, this was so full of really good information. It's one of those things I need to go back and review to absorb it all. But there is another question here that's any way we can verify the designate person for sick leave and unprotected leaves. We have had people taking time off for friends on several occasions.
So the first thing you have to do is look at how that specific law defines designated person. There are 3 different laws and 3 different designations. So the sick leave law has a different designation than the family medical leave law, and then this paid family leave insurance will. Some of those do allow you to designate a friend. So the first thing you need to do is look at that law and see if it fits within the definition of designated person. If they can do it for a friend, then there's really nothing to have them certify because they can declare anyone their friend. However, there is a limitation, and that is that they can only designate one person per year. So if they choose their friend Bob for this year, they're stuck with Bob being their only designated person for 2026, and in 2027, then designate someone different. And by the way, this time off is not paid by the employer. So I understand you don't want people taking leave if you don't really, if they don't get entitled to it, but the leave is not. So having to grant them leave doesn't cost you in their absence, but it costs you in terms of payroll.
And we have another question here. Thank you for that. Lisa Coates asks, labor poster updates for remote workers. Post on our workplace intranet and email the employee with links, or do we have to send the posters to them directly, email or snail mail?
So you can post it. The challenge is going to be, when you ordered the poster company, it came in a poster that you hung in your office. The challenge is finding a vendor that will have all of the required postings in an electronic format that you can post on your intranet, and then making sure you add to that the city postings. So if you used to get your poster from Costco, you're not going to have that. If you go through California Chamber of Commerce and you purchase the correct package, I believe they do have a package that has electronic posters. However, if you don't buy the package that includes the city ordinances, you have to go collect those on your own. So the first thing to do is identify every location where you have employees working, and then get the state and federal poster, and then you have to get the postings for all of the cities where people work. If you have employees in other states, you have a whole additional obligation beyond that. But short answer, yes, if you can post them, as long as you post all of them and you let employees know that they're there so they can actually know where to get them.
Terrific. And Lisa is asking another question. Wage order 16 for minimum wage. If we offer to provide tools, but employees prefers to use their own, do we still have to pay the higher 2x minimum wage?
If you're risk averse, you do. Here's the thing. I have that all the time. My wants to use their electric saw. You can let them do that. They file a claim later that you didn't pay them properly. It's going to be your burden to prove that the employee voluntarily wanted to do it. That is a very uphill battle for you to, because the employee is going to say the opposite. Well, I didn't know. I just brought my own saw. And by the way, hand tools do not electric tools or battery they don't include power saws and drill guns, and those are high ticket employers have to provide. So my recommendation is you provide them, you tell them they can't use their own stuff. Even if they want to, they can't. That's the only way you can protect yourself. If you're going to let them bring their own stuff, pay them 2 times minimum wage and consider that you're saving the money on tools. If they bring their own tools, however, you still have to pay for so maybe you pay them 2 times minimum wage and they bring their own saw. You still have to replace the sandpaper because that's a consumable. Replace the saw blade because that's a consumable. They can bring their own hammer, but you have to supply the nails. So, or they can bring a nail gun, but you have to apply the nails. So bring their own. First of all, it's hand tools. It's not ladders. It's not table saws, it's hand tools. And my advice is it's a cost of doing business for you to have supplies and the equipment necessary to do the work. You should be providing them. And if you're going to have employees bring their own, make sure they are hand tools. This is a case where people can file class actions against you. And every employee you've employed for the last 4 years can have one employee sue on their behalf to collect all of the costs of all of the materials that they brought because you didn't provide it. So you should, in my mind, consider the cost of supplies and equipment as part of what you charge your clients and your customers and provide them. Anytime you let them do what they want to do, know that you still have the burden to prove they voluntarily did it, and you'll still probably get hit with a lawsuit and a judgment. So my advice, don't do it. If it is hand tools, make sure you pay the 2 times minimum wage. Wage goes up every year. That means you have to increase that rate every year, regardless of whether it's time for salary or compensation increases. Anything you peg to the minimum wage, you're going to have to change every January 1.
Lisa Ann, this is Ed Curry. I'm going to ask a question here. It's kind of related to what you're doing, but it's a little different. During the pandemic, we found the best way to protect our employees was to send them home. We rapidly set them up for work from home. We later found out that was the best way to operate for us.
Yep.
Really well. We were advised to pay everyone a stipend because they're working home to cover their internet and power and stuff like that. I'm curious what your thoughts are on that.
Absolutely. Okay. So in California, we have Labor Code 2802, which is the law that basically says employers must reimburse or indemnify their employees for any expenses that they have to incur in order to perform their work. It's one of the reasons why you reimburse mileage for business mileage driven in a personal vehicle. So in the olden days, everybody knew if I have to go to the store and lunch for the meeting, you're going to reimburse me. I'm going to submit a receipt. You're going to reimburse me. And if I need to go on the way to work and buy supplies at Office Depot, I buy a case of paper, I'm going to come back to work and I'm going to turn in the receipt. You're going to reimburse me, right? The cost of doing business doesn't belong to your employee. Well, when we moved into remote work, which we did because of COVID, part of the business expense employees, now they had to supply the internet, they had to supply the phone, they had to supply the computer, they had to supply the chair. And in those cases, in COVID, they were required to work remotely. So they had to, under Labor Code 2802, reimburse the employee for the business related expenses. So a portion of their internet, a portion of their or Wi-Fi, a portion of their cell phone. So now post-COVID, so I'll give you this way. If you are requiring your work remotely, you must reimburse them for all the related expenses. You have to send them supplies or order them from Amazon. You have to you have to provide the printer toner if they're using their personal printer. You have to give them a stipend for using their own computer and their own cell phone and their own internet. And when I say required, I mean require them or the nature where the employee works requirement. So, for example, if you have an office space in Santa Rosa and you allow an employee to work from Roanoke Park remotely, but you have office space in your office for them to come and work, then I would argue you're not requiring them to work remotely. They're working remotely voluntarily because any day they want, they could come to your office and use your phone and your internet, etc. If that employee lives in Los Angeles and my office is in Santa Rosa, by hiring them and letting them work in LA, I am requiring them to work remotely because LA is not a commuting distance to Santa Rosa. So in my view, that is a required remote work and they should get a stipend.
Where could people...
If you have a voluntary situation and you have a place for them, view is you don't have to reimburse them because they're personally electing to do their work at home. I will say, though, still keep in mind that there are required aspects. Like we have employees who work in the office, but we have moved away from desktops and gone to computer phones, over the internet. My employees who need to access their cell phone authentication to get into the internet, reimburse them for that cell phone use. Even though they're not using it for the phone because they can use their computer or desktop at work, they are having to use their personal cell phone to get the code to get into the computer. So even if there is a very small mandatory use of a personal device, you have to reimburse for that. And most people choose to do that by a stipend because unlike pens and paper that I go purchase and can give you a receipt, I don't have a receipt that says I used my cell phone for 30 seconds every day to access my computer. And that's when employers try to set a reasonable stipend.
Thank you so very much. And you anticipated the next question I was about to ask.
Yeah.
To all or most of the crazy things that Trump officials say, but this
of that.
All right. And Lisa Ann,
and by the way, I am seeing class actions every month on the reimbursement issue, and 99% of the time is cell phone.
Where are people going to find out what are the typical reimbursement stipends they should provide? I'm talking about the amount of dollars.
Oh, people always ask me that, and there's no magical formula, right? Because it's like your receipt. What I recommend is, first of all, you have to do an audit of cell phone is used. Is it used to take photos? Is it used to post to the internet? Is it used as a phone to check emails, to text each other, to get into the computer? You have to understand how it's being used, what purpose. You have to understand who is using it because it may be different uses. Your supervisors may use it far more than your non-supervisor. Your people that work in the office use it differently than your people who are out on the road meeting clients or traveling. So you have to understand how they use it. You have to understand who is using it. Then you have to ask the employees and the supervisor because you may assume. I have so many clients that tell me we have phones on the computer, so nobody. Are you sure that you're never texting each other? Oh, I don't know. They're not supposed to. I'm like, well, ask because you're responsible for what your supervisors are doing. A very common use that I find when people swear to me that their employees use their cell phones for business. Oh, they're texting their supervisors when they're going to be absent. They are texting the supervisor, they work at different work sites and it's easier to text than pick up, or it's easier to email than to pick up the phone. So you may think they're not using it. I find almost 100% of my clients who tell me no one's using their cell phone for work, almost 100% are wrong. People want to use it. Your employees want to use it. It's easy. It's, there are a lot of pros and cons to it that go beyond clock work time that is an issue with cell phones. There's reimbursement. There's confidentiality issues. There are issues with protecting your confidential and trade secrets, your confidential information and trade secrets. There's business theft issues. There's all kinds of pros and cons that I could talk about with clients, but setting the stipend, how is it used? Who is using it? Then decide, do you want to continue it? If you find out that people are using their cell phone for texting and you don't want that to happen, issue a rule and then make sure everyone complies. But if you decide that cell phone use is needed, you have to just do an estimate. So how often is it used? Is it once a day? So in my office, our attorneys use their cell phone all the time. they get $75 a month. They use their cell phone to answer the phone. They use their cell phone to check email. They use their cell phone to text. They are all salaried exempt employees. Our secretaries, who are hourly employees, only use their cell phone to get into the computer for secondary authentication. They don't have their work email on it. They don't have Zoom on it for the office. They don't text each other. So we pay them $5 a month to reimburse them for that 30-second. You're having to kind of estimate out of the 24/7 use of a portion of that, and that will vary by employer, by profession, by even within your own company. So I don't have a crystal clear rule on it. I will say that I have clients tell me, well, my employees have unlimited minutes, so it isn't anything extra to use it for business. Nope, the courts have already said, can't do that. If you're requiring them to use it for business, they get some reimbursement from you. So, or saying, well, they did a business errand on the way home and stopped at Office. I don't have to pay them for that mileage because Office Depot was on the way home. Nope, they were still doing a business errand between your office and Office Depot. You have to reimburse them for that mileage. So expense reimbursement is really a big issue in wage and hour compliance and has led to class actions. It's far beyond what you normally think of as business expenses just being a deductible expense it is a big issue for employees. It is not subject to taxes for the employees because you are reimbursing them. If you can reimburse through payroll, but you have to make sure it's a separate line item on the pay stub and that it is not subject to taxes because it's reimbursement. It's not the payment of wages. So that's a little sneak peek of all the issues so quickly.
Well, I apologize
right.
for all the nightmares I'm going to cause in the attendees today.
I do want to say that if people end up having questions, they can reach out to me. I can give very general information. I can't answer any specific without them becoming a client because I have to make sure that we run through conflict checks and I don't have any conflicts of interest. So if someone writes to me and says, here's an issue with Joe, I can't answer that. If you just have like the ones that have been asked here, I can answer that.
So we do have
is my contact information, has that been provided? I'm not
sure. Actually, I'm going to insert it there so it's seen when you look at the recording.
Okay.
And we do have a Lisa Ann, but I want to be of your time and the other attendees. So I'm just going to give a statement about our next, and then if you have some time, we can answer the last two questions. How's that?
Okay. And I can also give people my email address.
Okay. So thank you all for attending, and those of you who have stayed on through the extended. I just wanted to mention that our event next month will feature Sean Flynn, the founder of Silicon Valley High Point Capital. Sean's talk is titled Things I Wish I Knew Before Starting a Podcast. Sean will share with us a step-by-step process to go from zero to becoming a successful podcast host. So hopefully you can join us for that. Sign up, as always, on modernideasforbusiness.com. The registration page should be going up in the next day or two. But with that, thank you for attending today. And Lisa Ann, the last two questions that I see here, I think at least one of them has a probably fairly quick answer. One, workers, what is the suggested guideline for distance from closest office location to determine required remote versus employee convenience request?
Oh my gosh. Yeah. That's a hard one because there isn't a black and white rule. And by the way, I did put my email address in the chat if anyone wants it. There isn't a black and white rule. So the courts would say, what's a reasonable distance, right? And the only way you're really going to know what's reasonable is if you get sued to a trial and a jury says, yeah, that's reasonable. So I have a conversation with the client about, how much time does it take to get to your office? Did you make when they were hired that this job is in Santa Rosa and this is your office space and you need to commuting, you don't want to commute, you want to work from home. So there's a lot of things that I would advise a client to help best reasonable argument that they can. Certainly, I would think that, I'm in Santa Rosa, anything beyond an hour and a half commutes, probably not expect them to come every day. It just really depends on a lot of factors.
Thank you.
I wish I had black and rules, but I don't.
And then the last question is from Daniela Ortiz. Is communication when an employee calls out sick considered using a personal phone for business? We have employees that don't use their phones for work since they are in manufacturing. But if they are absent or will be late, they will use a personal phone to call the office and communicate with their supervisors, managers.
Okay, so I'm going to say it depends. If it depends on how your policy is drafted and what your requirements are, is that they call. I don't consider the fact that they are using their cell phone to call in sick that would not be reimbursable. However, if your policy requires them to text, you can't text unless you have a cell phone. So I would say if you require texting, that is arguably a business use. I want to say one other thing where I find a lot of compliance issues with attendance policies. If you are allowing, not just requiring, but allowing employees to text their supervisor about their attendance. And if that text comes in, and this applies to a call as well, if a call or a text, so the employee who's going to be absent he doesn't have to be paid for reporting an absent and doesn't have to be reimbursed for calling an absent. But if the person to whom they have to report by phone, email, or text is an hourly overtime eligible employee, if that employee is receiving the text or call when they are off the clock, you have an off the clock exposure with that supervisor. Because if I'm getting an email or a call at 6 a.m. that Sam isn't coming into work and I'm not on the clock, I'm not getting paid to do work. So my recommendation to minimize wage and hour liability is all of the attendance reporting should either be going to a hotline or a voicemail that someone doesn't have to be at. Or if you need them because of the nature of your business, if you need them to let you know before the office opens that I'm not coming to work, the person receiving the text or the call or the email needs to be an exempt salaried employee, because then they won't be off the clock and you won't owe wages. I find this violation all the time, particularly in construction and office type environments where the worker has to notify their hourly paid supervisor or lead, and that person is getting the text and dealing with rescheduling and finding coverage at 6 a.m. when they're off the clock at home. That is a wage and hour violation because they're not getting paid for that time to deal with the attendance problem. So that's not new law. That's just an issue that comes up out of that attendance question.
Fabulous. Well, again, Lisa Ann, this has been so helpful. We've had a number of comment that it's been an excellent presentation. So thank you so much for doing this for us. And we look forward to having you back in the.
You're very welcome. Thank you very much. And I look forward to hearing from people if they have questions. Thank you.
You can find more presentations at this website, modernideasforbusiness.com. Please visit our library of past presenter. Visit us on YouTube or our podcasts on your favorite platforms.